we are going to start with the 4 panelists from the college who will start the conversation. We're not here to present as experts on Justice Ginsburg or her jurisprudence. We're not holding ourselves out as Ginsburg scholars by any means, but simply as people who, like many or most of you, were impacted by her life and her work on a personal and a professional level. So a couple of housekeeping matters before we get started. Here's a brief overview of how the conversation will flow this evening. We'll start with some remarks from our panelists, whom I'll introduce in just a moment. Then I'll let you know, and we'll open the floor for questions, comments, reflections from the rest of participants. When we do that, I'll let you know, and if you'd like to speak, please either raise your hand using the emoticon at the bottom of your screen, or you can also use the chat feature and just say, I would like to speak, and I'll call on people in the order of raised hands or chat comments. This webinar will be recorded, and it will be posted at a future date on the Arizona Law website, and I believe that also you'll receive a link, those of you who registered to that, posted recording. Also, please remember to check the College of Law's website for news on future LawCats Live and the master calendar for future LawCats Live events. So Justice Ginsburg's passing last Friday brings to the forefront of the national conversation a number of issues, right? Not least of which are the implications raised by the appointment of her successor. Tonight, though, on what's arguably the 231st birthday of the federal court system. On this date in 1789, Washington signed the Judiciary Act into law. And on the eve of Justice Ginsburg becoming the first woman to lie in state at the US Capitol, we'd like to put the appointment controversy aside and take this moment to reflect on the justice herself. The impact, personal, professional, or otherwise, that her life and her work has had on each of us. So I'm joined on the panel tonight by 4 of my College of Law colleagues. First, Professor Barbara Atwood has taught courses relating to civil procedure and family law for many years. Professor Negar Katirai directs the college's domestic violence clinic and teaches family law. Professor Griffin teaches civil procedure, remedies, and empirical methods in the law. And Professor Rebecca Sosi is a Regents Professor of Law and faculty co-chair of our Indigenous Peoples Law and Policy program. So Justice Ginsburg became a pop culture icon. I would say, I don't know if she ascended to that or if that's the right word to use, but she definitely became a pop culture icon in 2013 when her fiery dissent in Shelby County versus Holder inspired a 2L at NYU to create a Tumblr, dubbing Ginsburg the notorious RBG. Now, Barbara, I know that you have some thoughts to share about Ginsburg's opinions in Shelby County and in the VMI case, as well as some reflections on her notable aspects of her personal life. So, Barbara.
Thank you very much. It's great to reflect on this extraordinary woman. I find myself really wondering what made her be the way she was. I mean, she was just this superwoman, and it seemed to even get more so as we went through time when we knew she'd had terrible health issues and she was still doing what she was doing. So I like to just think first about where she came from. She was born to Nathan Bader, Russian immigrant, who became a furrier. He was Jewish. Her mother, Celia Bader, was born 4 months after her Austrian Jewish family immigrated. And they lived in a predominantly Jewish neighborhood in New York City. When Ruth was 2 years old, her older sister, her only sibling, died. A loss that surely must have left a profound mark on the family. And she was then necessarily the exclusive focus of her parents. She was the child. I think that all their love sort of focused on her and all their expectations for what their legacy might be. Like she carried this with her. And then when she started high school, her mother, her beloved mother, was diagnosed with cancer and dealt with it for 4 years and finally died a day or two before Ruth's graduation as valedictorian. Dealing with that, this sort of stark adversity, seemed like it didn't weaken her the way it might with some people, but gave her this resilience and strength and superhuman determination, and maybe an awareness that life is fragile and that she was going to make every moment count in her own life. Her Judaism is really interesting to me too. I'm Jewish. I'm married to a Jewish man, have Jewish children, but Ruth was raised in an Orthodox home, and when her mother died, in keeping with Jewish custom, she was not allowed to say the Kaddish during Shiva, during her mother's this grieving period. And people who know her well said that marked the break for her with sort of the religious observant kind of Judaism. She was what you might call a secular Jew after that, but this sense of being excluded from this very important ritual at that moment of grief was very profound for her. Incidentally, for Justice Elena Kagan, who also was Jewish and raised in an Orthodox Jewish home, when she was 12, she wanted to have a bat mitzvah because her brother was having a bar mitzvah at the age of 13, and she convinced her rabbi to have the first bat mitzvah ever in that synagogue. But he wouldn't let her do it on Saturday morning because that was special. He would only let her do it on Friday night. And I just find it fascinating. These two justices now on the Supreme Court, Ruth was, had pushed against these gender restrictions of Judaism. But at the same time, maybe the moral teachings of Judaism heal the world, make the world a better place. Maybe that had a lasting impact for them. Justice Ginsburg had a Jewish phrase from Deuteronomy on her wall, apparently in her chambers, that translated is, "Justice, justice, shall you pursue?" And she certainly did. She also was an outsider because she was Jewish, and she talked about that a number of times during the last 10 years. But in her confirmation hearing back in '93, she said, "I am alert to discrimination. I grew up during World War II in a Jewish family. I have memories as a child, even before the war, of being in a car with my parents, passing a place in Pennsylvania, a resort, with a sign out in front that said, 'No dogs or Jews allowed.'" Her belief in equality and her commitment to gender equality, I think, really it permeated her entire life, not just as a lawyer and a jurist, but in her personal life. And we've heard a lot in the last few days about the sort of amazing equal partnership that she had with her husband, Martin Ginsburg. But she took gender equality as this amazing sort of marching order when she was an ACLU lawyer and co-founded the Women's Rights Project. So I wanted to just I was going to talk about two cases. I don't want to take up too much time, but each of them had a personal resonance for me in different ways. And the first, as Professor Salmon mentioned, is the VMI case called Virginia versus United States. And that's the case that struck down the male-only admission policy at the Virginia Military Institute, a public institution, on equal protection grounds. But when she started that opinion, she cited two precedents that she herself had litigated and argued in the 70s that's established that gender discrimination was a violation of equal protection. There's still ambiguity about what exactly the test is for that, but they were her precedents. She had litigated them. And in particular, she mentioned a case called Weinberger versus Weissenfeld. And I thought it might be good to listen to her voice for just a couple of minutes.
Mr. Chief Justice, and may it please the court. Stephen Weissenfeld's case concerns the entitlement of a female wage earner's family to social insurance of the same quality as that accorded the family of a male wage earner. 4 prime facts of the Weissenfeld family's life situation bear special emphasis. Paula Weissenfeld, the deceased insured worker, was gainfully employed at all times during the 7 years immediately preceding her death. Throughout this period, maximum contributions were deducted from her salary and paid to Social Security. During Paula's marriage to Stephen Weissenfeld, both were employed. Neither was attending school, and Paula was the family's principal income earner. In 1972, Paula died, giving birth to her son, Jason Paul, leaving the child's father, Stephen Weissenfeld, with sole responsibility for the care of Jason Paul. For the 8 months immediately following his wife's death, and for all but a 7-month period thereafter, Stephen Weissenfeld did not engage in substantial gainful employment. Instead, he devoted himself to the care of the infant, Jason Paul. At issue is the constitutionality of the gender line drawn by 42 U.S.C. 402G, the child in care provision of the Social Security Act.
And she went on to make a powerful argument, but that shows you this kind of understated way she simply laid out the facts, which were truly tragic facts, appealed to the justice's sense of fairness, and won her case. Moving back to the Virginia Military Institute case, they're writing for the court. She says that this exclusion is based on outdated assumptions about males and females, and it deprives women of the huge opportunities that would be available to them if they could get into VMI. In the case, Virginia had established something called the Virginia Women's Leadership Institute at Mary Baldwin College. It was, in a sense, a separate, they wanted it to be viewed as a separate but equal program where women could get their leadership training at Mary Baldwin and they could keep VMI as a male-only institution. That didn't go over well with the court, and Justice Ginsburg pointed out that people who entered Mary Baldwin College had lower SATs, that the faculty had fewer PhDs than at VMI, and that the educational experience was deficient as compared to VMI. My personal connection to the case is that I am a product of that deficient institution. I graduated from Mary Baldwin College in 1969. Not a shining moment in that institution's history to be the kind of deficient alternative that helped win the case for the plaintiffs in the VMI lawsuit. But let me just say a few more words about the other case that Professor Salmon mentioned. That's the Shelby County, Alabama versus Holder. That's the case that essentially nullified Section 5, the preclearance provision of the Voting Rights Act. And my connection is that I worked in the Voting Rights section of the Department of Justice in the 1970s. And one of my jobs was to handle these preclearance requests under Section 5. Every change in voting practices, even moving a polling place in the covered jurisdictions, which are the southern states and later some western states with high native populations, they had to get an okay from the department before they could put these proposed laws into effect. And they had to show that they would have neither the purpose or effect of denying the right to vote on account of race or color. It was very heady stuff for me. I was out of law school 2 years to be doing that. But we mostly granted preclearance, but sometimes not when it seemed like it would have a really pernicious effect on voting rights. Congress took up the reauthorization of that act in 2006 and found a lot of evidence for it to be extended. And the lower courts in that case also agreed that there was plenty of evidence, plenty of sort of showing across the board that we still needed this kind of extraordinary remedy. But the majority in Shelby County held that there was no longer a basis for continuing this preclearance structure, the coverage formula, and essentially nullified it. And Justice Ginsburg's dissent has been quoted frequently in the last few days, the off-cited passage where she says getting rid of Section 5 because we don't have too much lingering effects of race discrimination in electoral practices is like throwing an umbrella away because in the rainstorm because you're not getting wet. But I wanted to quote a different part of her opinion in this same section. She says, "The sad irony of today's decision lies in its utter failure to grasp why the VRA, the Voting Rights Act, has proven effective. The court appears to believe that the success of the act in eliminating the specific devices existing in 1965 means that preclearance is no longer needed. With that belief and the argument derived from it, history repeats itself. In truth, the evolution of voting discrimination into more subtle second-generation barriers is powerful evidence that a remedy as effective as preclearance remains vital to protect minority voting rights and prevent backsliding." She warned of backsliding, and she was right. We've seen since then very stringent voter ID laws, restrictions on who can use mail-in voting, timing restrictions, etc. We see these consequences, and she was absolutely right. There is a bill in Congress right now, the John R. Lewis Voting Rights Act, that will address these if it succeeds. But let me one more comment. Finally, Justice Ginsburg paid me a lovely compliment back in 2006 in a case called Marshall versus Marshall. It was an obscure dispute about whether a federal court could hear a tort claim pressed by the Playboy playmate Anna Nicole Smith against a millionaire's estate. And it touched on a doctrine that I had written about. And in the first paragraph of her majority opinion, she cited an article I had written back in the 1980s. I heard from a lot of former students that day, the day the case came out, saying, "Way to go, Professor Atwood. You're in the same case with Anna Nicole Smith." Just was kind of funny. Anyway, I'll stop there. Sorry if I went on too long.
Thank you, Barbara. So turning now to Negar, I know that you had wanted to share your experience kind of getting to know Justice Ginsburg through teaching family law. So Negar.
So exactly, yeah. My admiration for Justice Ginsburg really grew in teaching family law. I began my career as a practitioner, and while I was familiar with the headlines of Supreme Court cases, I wasn't necessarily reading them. But in teaching family law, I, of course, did delve deeply into them, and I took note of Justice Ginsburg's quiet, I think, Barbara, you said something like understated advocacy, and I took note of that. I first took note of it in so I'm glad you talked about that. But I also took note of it in that VMI eventually that jurisprudence led eventually to Obergefell versus Hodges. So to me, Obergefell versus Hodges is but one example of a case that brings her understated advocacy full circle. So I'm glad that Professor Atwood has spoken about VMI, and I'll focus on Obergefell, which of course is the Supreme Court's landmark decision on same-sex marriage and marriage equality. Kennedy wrote the opinion, and in response to arguments by some of the other justices on the court that marriage had traditionally been defined as a union between a man and a woman, Kennedy wrote in various parts of his opinion that history is the beginning of these cases. And then further on he wrote, "The history of marriage confirms its centrality, but it has not stood in isolation from developments in law and society. The history of marriage is one of both continuity and change. That institution has evolved over time." So he was referencing coverture and this concept that we inherited as part of our colonial heritage that held that a woman's legal identity was derived from that of the men in her life. At birth, the female baby was covered by her father's identity, and then when she married, her identity was covered by her husband's. And in Obergefell, Justice Ginsburg said exactly that. She said in the oral arguments, she said, "Marriage today is not what it was under the common law tradition, under the civil law tradition. Marriage was a relationship of a dominant male to a subordinate female that ended as a result of this court's decision in 1982 when Louisiana's head and master rule was struck down, and no state was allowed to have such a marriage anymore. And then she asked rhetorically, would that be a choice that a state should be allowed to have? So to me, that understated advocacy that she did in the oral argument is clear in that her reasoning did influence Kennedy. And of course, this reasoning maps with her history and her advocacy as a lawyer for sex equality that she undertook before becoming a justice. So as I said, I became enamored with her advocacy in teaching family law, and then I started to just want to know more about her. And I started reading, and if you haven't read these are, I really recommend them, Jeffrey Rosen's Conversations with RBG. There's excerpts of them in the Atlantic, and then there's a whole book, of course. So I'm going to read just a few of them that I thought captured who she was. So on being mindful and purposeful, she said that my mother's advice was, don't lose time on useless emotions like anger, resentment, remorse, envy. Those, she said, will just sap time. They don't get you where you want to be. So that's very hard to do, and she admitted that. But she also admitted that I realize if I don't do it, I'll lose precious time from productive work. And I find that inspiring because it's clear from her history of advocacy and her history as a justice that she was incredibly productive. So I aspire to that, even if I don't always meet those goals. And then I also was inspired by what she said about her own career in terms of the role that she played in bringing about change. I was just struck by her humbleness. And maybe that's not the right word. I think it was more, she had a view of herself as somewhat of a conduit for change. It was almost, I'm glad that Professor Atwood talked about her spirituality, because it was almost like a spiritual approach to doing one's best to bring the light, which I know Jeffrey Rosen has kind of tied to the great traditions, the great religious traditions from whichever one you want to choose. All of them kind of talk about bringing the light. So she said, none of the cases in which I participated in the 70s were test cases. They weren't staged cases. We weren't searching for plaintiffs. There was a revived feminist movement. People were alert to the unfairness of drawing lines on the basis of gender, and they began to complain. I was just fortunate to be around at the right time. Women and some men forever have been saying the same thing, but society wasn't ready to listen until the 70s. I was there and a lawyer and able to take part in the movement for recognition of women's equal citizenship stature. And the other quotes I wanted to read had to do with her empathy, which I think she would categorize as a useful emotion rather than a useless emotion. So again, I'm glad I'm following Professor Atwood, because she talks about her parents' experience and her own experience losing her sister. She says, it may have begun when I appreciated how much my parents were affected by the death of my sister. So I knew what it was like to grieve. If I had to point to any one thing, I'd say it was growing up with an understanding of what it means to have a devastating loss in one's life. And I think you see her empathy throughout her advocacy. One case that struck out to me is actually one that originated not far from here in Safford, Arizona. It was a case, Safford Unified School District versus Reading, where a 13-year-old student had been made to strip to her bra and underpants and then asked to pull them away from her body, exposing her breasts and her pelvic area by school officials. And when that case was at oral argument, Justice Ginsburg was the only woman, and the other justices were kind of joking around, locker room talk, if you'll have it, about how the search was done and kind of making jokes about it. And she didn't really appreciate that. And she made it clear in an unusual interview. Usually justices don't talk about pending cases, but she had an interview with USA Today, and she said, well, they have never been a 13-year-old girl. It's a very sensitive age for a girl, and I don't think that my colleagues, some of them, quite understood. And she said that her colleagues had failed to appreciate what Ms. Redding had endured. And then that understated advocacy, or maybe not so understated in this case, speaking to the press, but that also had an impact, because Souter, in writing for the majority in the eventual decision on that case, did talk about how the search for these 2 Advils, that's what the search was for, didn't justify an embarrassing, frightening, and humiliating search. So she had an impact on her colleagues there as well. So finally, I'm going to leave with some of her own words about her hopefulness, which I think is appropriate in this age and time where we're living in a pandemic of all, among other things that are hard to endure. But asked about threats to constitutional values that she had defended so eloquently and what the future of our democracy was, she said that she was hopeful, and Jeffrey Rosen asked her why. And she said, because we have in the past, and we will again, our country has gone through some very bumpy periods. But I'll tell you the principal reason why I'm optimistic. It's the young people I see. My lawyer, granddaughter, my law clerks are determined to contribute to the good of society and to work together. So the young people make me hopeful. They want to take part in creating a better world. Think of Malala. Think of Greta Thunberg of Sweden. What is she, 15, 16? Yes, I'm putting my faith in the coming generations. And she mentioned how she agreed with the words of Learned Hand when he said, when liberty is lost in the hearts of men and women, no court can restore it. And in explaining why she agreed, she said that courts are not leaders in social change. They follow after movement in the larger society. Change occurred only when they came out and said, this is who we are and we're proud of it. Once they did that, changes occurred rapidly. So I'll end my comments with that.
Thank you. Chris, I know that you wanted to talk about Justice Ginsburg as an impact litigator and as a law professor, and about her commitment to access to justice through civil procedure. So, Chris.
Yes, thank you, Susie, and thank you to my colleagues who shared their comments just now. I'll start with the law professor part, and I think a lot of eagle-eyed watchers of the court over her tenure on the bench know that she was the consummate civil procedure professor. That's how she started out, teaching at Rutgers Law School, going on to Columbia, and she had to remind her colleagues on the bench when they were getting the law wrong, especially on the difference between general and specific jurisdiction. I promise I will stop there with doctrinal discussions of CIPRO. But it should be mentioned that she was a giant in the field. She is rightly remembered for her litigation and for opinion writing on gender equality, but she made significant waves and progress in our understanding of how the rules of the road are supposed to operate, both in majority opinions and in dissent. We think a lot about Nicastro and Daimler. We also think about Erie, another favorite of 1L students across the country. She had a blistering dissent in the Shady Grove case about the proper application of state or federal procedural law. And I would just be remiss if I did not share with this group that she was a giant in civil procedure. There's another aspect to her work as a law professor, keeping in mind that she got that job. It's remarkable to think that she got it in part because she couldn't do a lot of the other typical work that graduates of Columbia Law School or Harvard Law School would have done. She was notably and infamously turned down for a Supreme Court clerkship with Justice Frankfurter because he would not consider hiring a woman to be one of his law clerks. So she stumbled her way into legal academia, first at Rutgers, as I mentioned, and she was not really focused, based on my understanding of that time, on issues of gender discrimination and equality. And it wasn't really until her move to Columbia where her students would point out that there was not even a casebook on the subject, that she helped co-author the first one in the field. And it wasn't until after that experience, going to the ACLU and working with them on impact litigation that Barbara mentioned, that well before entering the bench, she started to find the voice for the experiences that that Barbara mentioned, and that definitely must have been injurious to the way she thought about her own path towards other women's path through the world in the US. And then she was able to bring that to light through her litigation. And we're having this event in a law school that is surely to serve the United States, but in particular, the great state of Arizona And I want those of us in the law school community in particular to be mindful of how one can take the work that is done within the walls of the building and then actually do something with that of great importance. It's rare for law professors to go from full-time teaching into something like impact litigation as their step up to the bench. That's exactly what Justice Ginsburg did. And I think it's quite an example that she set that has very few precedents, if any. The one that comes to most of our minds is Justice Thurgood Marshall, who started out with the NAACP Legal Defense Fund before he was sent to the Second Circuit by nomination by Johnson and then to the Supreme Court. It must be so fulfilling and gratifying to take a body of work in landmark cases, as both of them did, and then get to work even more on that on the other side of the bench. And I just want all of us to be mindful of the lengths and depths to which the work that we do at Arizona Law, it may not reach those heights. We can always dream and hope, but there are ways in which we can actualize the conversations that we're having here in Tucson and around the country towards these greater goods. It is deeply inspiring. And I agree with my co-panelists that there was something that sort of positively snapped in Justice Ginsburg around the Shelby County decision. It made her voice even stronger. She started to read her dissents. She started to adopt certain types of jabot, or the collars that we know and love. And it's a reminder that even if we're feeling that there are injustices and we feel them deeply and we talk about them with our students, no doubt as she did with her beloved husband, Marty, that at some point there's going to be something that is pushing us to really discuss that with a wider group. We're getting to do that right now. There are a lot of opportunities at the law school this year to talk about racial justice issues that have come to the fore since the late spring and early summer. And I will try to be as mindful as I can of Justice Ginsburg's example and the model that she set, where you can push for change. You can push for it in incremental fashions. Being the minimalist that she was, the stature, as we all know, was not grand either. She was a short woman that was relatively soft-spoken, but her words magnified and were amplified by the force and the integrity that she brought to the job. So I will conclude my thoughts by just hoping that we remember the whole body of work that she brought to the court and the amazing example that she sets for us as professors, for other jurists, and for our students.
Thank you, Chris. Well, in reflecting on that whole body of work as we are tonight, and in talking about things like justice and equality and fairness, we'd be remiss if we didn't acknowledge the complexities of Justice Ginsburg's work and her legacy, particularly in the area of Native nation sovereignty and criminal justice reform. Rebecca, I'm hoping that one particular example is Justice Ginsburg's majority opinion in the 2003 Cheryl v. Oneida Nation case. And Rebecca, thank you so much for agreeing to talk to us about that.
Thank you, Professor Salmon. And thank you to all my wonderful, distinguished colleagues that have brought such a beautiful set of dimensions and experiences to the discussion of Justice Ginsburg, who was truly an amazing justice in our Supreme Court's history. And I acknowledge that and I honor her. And probably many of the folks in the audience and beyond would agree with me that in a near time to somebody's transition, that's a sacred time that you remember them and you remember all the things that they brought to us that we have benefited from. And that's the spirit in which I agreed at the last minute to come and offer some thoughts. on her Indian law jurisprudence, in particular, the City of Sherrill case, which I know some of my students were concerned with. I teach federal Indian law. So I have to say that part of the work has already been done for me by my amazing colleagues, Professor Matthew Fletcher at Michigan State and Professor Carol Goldberg, who was my faculty mentor at UCLA. And they just put together a blend of remembrances about all of her Indian law cases. And according to Matt Fletcher, she voted in 51 Indian law cases in which the Supreme Court issued an opinion, 4 tribes in 23.5 of those cases, against tribes in 26.5 of those cases. One of those cases, obviously, the tribe had a partial win. And in one case, she voted against the tribe and the federal government in favor of individual Indians. And that was a case where she upheld their property rights. There was going to be a federal law that caused an escheat of their fractional interest in the estates that they had inherited from the 19th century allotment policy. Today, that can number in the 1/100s and beyond. And your interest may be worth, and I think at that time there was one interest that was worth 0.01 of a penny per year in lease revenue. And obviously, the federal government, the tribes wanted to condense all of those interests into a property interest that you could have the tribe manage and lease and do whatever it wanted to do. And she said, no, property interest is a property interest. That's sacred to these owners. And that, in fact, is what happened. It was struck down. So having said that, I also want to say that she joined Justice Gorsuch in the McGirt case. And we just had a wonderful program on the McGirt decision. And you will know that Justice Gorsuch did a historic thing in that opinion by finding the existence of Indian country had never been extinguished by the federal government in Oklahoma. And there was reservation land there for purposes of Major Crimes Act jurisdiction, 5-4. She voted with him in a very principled opinion. Now, it's very ironic that the opinion in City of Sherrill dealt with an issue that some people would say is sort of similar in some sense, because it dealt with the claims of the Oneida Indian Nation, which was a very powerful Indian nation. At the moment that the United States was formed, the Oneida Indian Nation had been in power in its territory since before the British, but certainly during the British regime and beyond. So they were powerful, and they had a reservation up there. And that reservation was acknowledged and ratified by the federal government, Congress. And they had a treaty with the United States. They had a political relationship. But as we know, in that terrible history, things happened. And the Oneidas were wrongfully removed from their historic lands in New York. And they were taken to another state where they had a reservation. Fast forward to the modern era, City of Sherrill is a 2005 case. The Oneida Indian Nation purchased lands in fee on its historic reservation, which had never been extinguished under federal law by Congress. And it was seeking something very simple, an exemption from New York state taxes on its lands, because it owned them, and it was an Indian tribe in Indian country, and per the rules, exempt from state taxation. And she said no. Why? As a matter of law, they should have had a tax exemption. All of the law showed that. She said, well, that's very valuable land. The Oneidas haven't been there for over 100 years. You know, the people who are there now have settled expectation interests, and we can't disappoint them. The state needs to be able to tax, you know, everything needs to happen. You know, we ought to treat them basically as any other landowner coming in here. And since it wasn't on the actual diminishment issue, that wasn't the issue, it was only on the tax exemption issue, she applied a very strange form of equitable doctrines of laches, et cetera. So for those of you that study remedies, those technically weren't applicable either, but it was the spirit of that idea that after such a long period of time, your legal rights can be in some sense diminished or extinguished by these principles of equity in favor of the current residents and landholders and, you know, states that are in the vicinity now. Now, why did she do that? I don't know why she did that. It turned Indian law on its head. It certainly created a set of nightmare experiences for the Oneida Indian Nation, because they have had a long series of litigation to actually reclaim their sovereignty and their jurisdiction over their reservation. But that is the case that she decided. Now, I think having said that, you have to take people's jurisprudence in context. And I have to say that just from my own perspective as a scholar of Indian law, and I also taught constitutional law for many years, you know, she really was an avid proponent of individual rights. And when I look at many of her opinions, I see her concern over what's going to happen to people. And she tends to shape the cases that way, which is a very different type of analysis, but completely consistent with what my colleagues have noted about her. So that is my humble opinion, and I am so happy to join you here tonight. Thank you.
Thank you. So now we want to take time to invite your comments, your questions, your reflections. Please raise your hand or let us know in the chat if you would like to join the conversation. The director of our law library has shared in the chat the link to the conversations with RBG by Jeffrey Rosen that Professor Katirai mentioned in her comments. So those are there.
Susie, Chris Griffin, the senior Chris Griffin had a question.
Yes.
It wasn't a question as much as a comment. I am, as I like to refer to myself when I am in the third person, as Chris the Elder. I'm the father of the Chris Griffin who's already presented. And he'll be forever embarrassed about my intrusion into the conversation, but I've lived with other times that I've embarrassed him, so I'll live with that. Two observations. I had the privilege of serving on the American Bar Association Commission on Women in the Profession back in the early 90s. And we established, some of you may know, we established an award named after the first woman lawyer in the United States, Margaret Brent from Massachusetts. And in 1993, newly appointed and confirmed Justice Ginsburg was one of our Margaret Brent Women Lawyers of Achievement Award winners. And I got to meet her and spend a good quality time with her on that occasion. And I must say that having met her on that level, as opposed to any type of either academic or jurisprudential level, was special because you get to know a lot about a person in that circumstance. And she had just joined the court. And so as I watched her renown grow, I felt privileged to have met her when she just joined the court. And you do, when you know and meet somebody on that level, you learn as much about them as you do when they serve as a professor or a judge. And everything that we know about her as a constitutional scholar and as a jurist was further confirmed by my personal experience with her. She had a quiet dignity about her that was unforgettable and that was made quite an impression on me. And on that particular program, I was called upon to introduce Joyce Kennard, who was a justice of the California Supreme Court at the time. And so I just wanted to share that having had that brief personal experience with her was, as I watched her, and when you say myth and legend, you sometimes suggest that it's not deserved, but certainly her myth and legend were both deserved. The other observation I want to make, and it comes from my years of service on that Commission on Women in the Profession, and then my later service on the ABA's. I was the initial chair of the ABA's Commission on Domestic Violence. And I'm struck by the fact that we're now in 2020, and my service on those two commissions was in the early 90s. I look at the attendees, the participants in tonight in Tampa, afternoon in Arizona. And it was an issue then, and it remains an issue now. And that is the number of men who don't pay attention to these issues and don't either want to or take the effort to appreciate what someone like Justice Ginsburg and her legacy mean to all of us. And there's this compartmentalization of women's issues. Secretary Clinton, of course, said in Beijing that women's issues are, or women's rights are human rights. And one of the obviously continuing task that we have is to convince men that the types of issues that bring this discussion to the fore should be and are as important to them as they are to women. And it's a message that we were trying to communicate. I don't even want to count how many years ago that was, but being here on the program with my son, I did want to make those observations. So I hope they were to some extent helpful and did not mortally embarrass him.
Thank you so much for those great stories. I know Professor Lett had a story to share. Sylvia.
Thanks, Susie. So last January, was it, Susie? We were at the Double ALS conference, and the notorious RBG was speaking in person. And I just have to say that it was all that you would expect and hope it to be. I've never been in a room with, how many people were there? Several hundred lawyers. And it was like we were at a rock concert, and just the excitement in the air and the giddiness. And when she came out and spoke, and she looked fabulous, and she was eloquent and meaningful. And all I can think of is like the only time I've seen people with that energy is like when I went to a Beyonce concert. So she's just, I just feel so privileged and lucky that I got to see her in person. So that's it.
In the chat, I just wanted to highlight Juno McCallum, who happens to be one of my students and my writing fellow, and obviously I chose extraordinarily well, has shared some of Ginsburg's thoughts on legal writing, all of which I wholeheartedly endorse. Professor Marcus, did you want to share more? I see, Lynn, that you have some comments about the immigration cases and Justice Ginsburg.
No, just that that she was always siding for the right to a bond hearing. There have been the right, at least a decade ago, there was a law that the Supreme Court interpreted not to authorize indefinite detention of people who had, final orders of removal but couldn't be removed, and just that, many of those, she was always very consistent about the individual right to liberty for immigrants.
Thank you. Anyone else have comments they want to share? Professor Lee, Eunice Lee, please, yes.
I'll just say a couple sentences. So my first job, I think those of you who attended David Cole's McCormick lecture know this because I mentioned this there, but my first job after clerking out of law school was at the National ACLU Immigrants' Rights Project, which is part of well, they have two offices, New York and San Francisco, but I was in the New York office, which is where the National ACLU legal department is. And even though I wasn't in the Women's Rights Project, when you're a fellow, all of the fellows in the different projects tend to hang out, trade stories, talk about their supervisors, et cetera. And I think, just what I would share is that Justice Ginsburg's legacy there was so strong that even as somebody who wasn't part of the project she founded, you know, being a young woman, being a litigator, learning to litigate there, she left just enormous shoes and enormous legacy that continues even decades after her departure. And I would say, I think it was an homage to her that we called ourselves the women, the fellows year, that year and subsequent years called themselves the 125 Broads. 125 Broad Street is the address of the National ACLU, and that continues to this day.
That's fantastic, thank you. Don Powell, I know you had your hand up.
Thank you. I just wanted to comment. I'm a graduate of the U of A Law School and I've practiced in Phoenix for about 47 years. And you know, sometimes it's difficult as a practitioner to the comments that come in about attorneys and the negativity, et cetera. But I could not be more proud of my profession and our profession because of Judge Ginsburg. And again, it just makes you feel like you really chose the correct profession. And
I know that just to echo what Mr. Powell was saying, I know that was my reflection this weekend after my initial just grief and concern, was to reflect on how proud I am to be a member of a profession that included her, and that to be a member of a profession that takes as its central vow to fight for the rights of other people. So, Justin Padot.
So as someone who focuses on environmental law, one of the sort of lasting legacies of Justice Ginsburg was her stemming the tide, it seemed, Justice Scalia shutting the courthouse door by narrowing standing doctrine. And the case I'm thinking of is Friends of the Earth versus Laidlaw, which significantly expanded the ability of those who benefit from federal law, like environmental law, to bring suit and have standing. And you know, I think in the absence of that decision, in the absence of that change in sentiment on the Supreme Court, we would have a much more crabbed environmental law today, in which most people, if you aren't being regulated directly, in other words, people, would be shut out, and instead we only corporations, industries, and the like could challenge environmental protection, but no one could challenge their violation of environmental law. So.
Thank you. And I know Lynn, Professor Marcus notes in chat that her Aunt Shirley was a personal shopper and may have helped RBG with her fashion. So that's a fun note for those who can't see the chat. Well, I know that we only have about 2 minutes left. So I don't know if, I know that Professor Katirai had to leave us. I don't know if any of our panelists want to share some final thoughts.
I'll just say I found it really moving, this idea that we are in a profession that includes an extraordinary leader like Ruth Bader Ginsburg, and I'm hoping that the law students that are following everything about her right now, not necessarily on this Zoom call, but that they are inspired as well, and remember that she started just like they are right now, and sort of slugging, working their way through law school. She was just an extraordinary force, and she really, really lived up to her goal of pursuing justice. And that is what we are all about.
Chris, did you have anything you wanted to add?
Not really. Barbara has said it all, especially my agreement with looking to her as a role model. And maybe I would also close, how about this, that thankfully our female students do not live in a world in which Dean Mark Miller is asking any of them why they are at this law school taking a seat from a man. But it doesn't mean that even though we don't deal with that humiliation, that there aren't still barriers to entry into parts of the profession, into parts of academia for women, and also notwithstanding the great work that other organizations like my father mentioned, the ABA, do, that we still have a lot of work to do. She knew that, we all know that, and I encourage all of our students, regardless of their gender, to keep their eye on what is still standing in the way for all people, regardless of their identity. Whatever those barriers are, it's our job to help dismantle them.
Thank you. Thank you. And thank you all for joining us. And please do check the Arizona Law website for future LawCats Live opportunities, and check your inbox for the link to the recording of this episode, webinar. Okay, thank you all.